On Thursday, March 7th, 2024, the trial against James Crumbley kicked off with opening statements. If you're not familiar, James Crumbley is the father of Ethan Crumbley, also known as the Oxford school shooter. On November 30th, 2021, Ethan brought a Sig Sauer to school and in the middle of the day opened fire on his classmates. He reportedly killed 4 classmates and harmed 6 classmates plus 1 teacher. Ethan pled guilty to 24 charges, which included murder and terrorism, and in December 2023, he was sentenced to life without parole. But this case is also unique as far as school shooting cases go because the state of Michigan decided to also charge Ethan's parents, Jennifer and James Crumbley, for their roles in the events leading up to the shootings. Both Jennifer and James were charged with 4 counts of involuntary manslaughter each. And in February of this year, Jennifer was convicted of all 4 counts. Now, James is on trial for the same and faces a felony conviction and up to 15 years in prison. In this video, we're recapping days 1 through 3 of James's trial. This video is a bit longer than I was hoping it to be, but it is essentially everything that you need in order to get caught up on this trial in case you haven't been able to watch it in full. So let's get into it. First off, as I mentioned before, this is a very unique case, and there is a mixed set of reactions that people have had to the fact that the parents have been charged. Some people are applauding this decision, basically saying like, okay, finally, some parents are being held accountable for the way in which that they are storing their guns or making them accessible to their kids who are ending up harming other people with them. Others, however, have expressed some concern that this is maybe the start of a trend of what they would consider to be government overreach into Second Amendment rights of parents of unpredictable children. For my part, I will say that according to the allegations, this case is factually very unique, even among other school shooting cases, in that the state has alleged here that the parents knew that their kid was seriously struggling with some very serious mental health issues, and that they ignored these issues when they chose to basically actively put a gun in his hand. Here, it's the alleged affirmative steps that they took to give him access to those firearms, coupled with the alleged lack of steps that they took to take care of their son's mental health, that seems to make this case particularly different from others. But again, that's according to the allegations, and it'll be really interesting to see what the defense has in terms of their case and what they're able to argue to the jury. Okay, so on to the specifics of day 1. How did the two sides do with their opening statements? If you want to see my complete thoughts on the opening statements, I'm linking in the description below to a live stream where I covered the entirety of both sides' opening statements, paused in between, gave my thoughts and all of my impressions. Otherwise, if you'd prefer to see a bit more of a summarized version, keep watching. So for starters, remember that with opening statements, the goal is basically to do a couple things. First, give a framework for what the case is all about and what issues are important for the jury to understand and to ultimately make decisions about. And second, the goal is to give basically a roadmap for what the jury can expect to see. A good opening statement will typically end up making a bunch of promises as to what the jury is going to see and what all of that is basically going to add up to. And then by the time the trial gets to closing arguments, the jury will be able to determine if that side kept those promises with the evidence that was actually introduced. So in the opening statement, the goal is not to throw all of the evidence that you have at the jury at the very beginning, because they are supposed to be starting fresh, knowing nothing or almost nothing about the case. So really what you're doing here is introducing the jury to the case, ideally in a narrative format. If it's a really simple case, the opening statement does not need to be complicated. In fact, a shorter opening statement can often keep the jury more engaged. And if possible, it's always great when the opening statement can include a theme that can be repeated or echoed throughout trial, throughout the coming witnesses that they'll be putting on the stand or even cross-examining, so that the attorneys can flag these important moments for the jury to remember and take note of. So that's the opening statement in a nutshell. And I will say, in this particular trial, both sides had a solid opening statement. To begin, they both kept it very brief. They didn't go on any longer than they really needed to, and they both got the message across to the jury as to what their main messages were. For the state, the basic theme is that James Crumbley had a series of tragically simple or tragically easy things that he could have done to prevent the mass shooting. One of these was properly locking up the gun. They showed a photo of a cable lock that he bought with the gun 4 days before the shooting, which was still in its original packaging, meaning that he didn't use the cable lock to secure that gun. They also talked in the opening statement about the fact that Jennifer and James Crumbley were pulled into a meeting with Ethan and a guidance counselor that morning, the morning of the shooting, because of images that Ethan had drawn on his math assignment depicting essentially a shooting or a mass shooting, and writing words and phrases on there that seemed to be a call for help. And I will say, this line that the prosecution delivered about the tragically easy things that James Crumbley could have done was a line that really stuck with me, because here you have 4 kids that lost their lives that day, 7 other people who were injured, and a whole community that was forever changed as a result. And so if the evidence does end up showing that James Crumbley could have done 1 or 2 simple or easy things to prevent the shooting, it makes his action or lack of action all the more outrageous and heartbreaking. Continuing on, the state also said that James Crumbley knew that Ethan was going through serious mental health issues before he bought Ethan the gun 4 days before, and that he ignored those issues and even told Ethan to, quote, suck it up. They said he was around to notice these issues and that he was totally able to do any of these tragically easy or tragically simple things because his job is flexible. He had been a DoorDash driver for a few weeks at that point after previously losing his job. And then the state talked about the fact that Jennifer and James Crumbley left town after being charged. Now, this was, of course, to indicate that the defendant had a consciousness of guilt. But I will say that when the defense attorney stood up to deliver her opening statement, she did indicate that this apparently was at the advice of counsel, that they left because they were receiving death threats over the school shooting. And so focusing on the defense opening statement, her basic theme was this: James didn't know that his son was struggling in this way. She said he loves and cares for his son and that the state isn't giving a full story. Instead, they're basically steamrolling him and overreaching with this charge. And she said even though his job is flexible, that doesn't mean he's not serious about or focused on working that job to provide for his family. And so she said that he wasn't able to take Ethan home at the end of that meeting with the guidance counselor on the morning of the shooting because of the fact that he needed to make money for his family. So here, like I said, the defense theme really is that he didn't know the dangers that were developing in his son's mind and in his behaviors. And if he didn't know, that means he couldn't be criminally negligent, which is an essential element of involuntary manslaughter. So let's talk about that for a second. In Michigan, there are a few elements for this charge. The first element is that there's a death that was caused by the defendant's action or inaction. The second element is that that death was a foreseeable result of the defendant's action or inaction. And the third element is that the defendant was criminally negligent in acting or failing to act. Criminal negligence is defined as when a person knows that what they're doing or not doing creates a serious risk of harm, and when they consciously disregard that risk through their behavior. Criminal negligence also asks whether a reasonable person in the same or a similar situation would have perceived that risk. So even if they didn't know, should they have known according to what a reasonable person would have known? So because of this aspect, evidence of other people flagging Ethan's mental health issues and raising them, especially to the parents, is going to be strong evidence of criminal negligence. Okay, so that's the opening statements. On day one, the state also opened up its case in chief by starting to put on their witnesses. The first witness of the day was Molly Darnell. As soon as she said she was a teacher at Oxford schools, you just knew this was going to be a very emotional start to this trial. And that's exactly how it played out. And this is a smart strategy by the state, specifically starting with an emotional witness who can give the narrative of what exactly happened. I'm going to give some details from this witness testimony, but just know that I'm not going to do that for every Oxford shooting witness. The reason is not to sugarcoat what happened or to lessen the real weight of the tragedy of what happened that day. Rather, I just don't want these recaps to turn into splashy gore fests, especially when the issues in this trial were more about James and his relationship with his son and what he could or couldn't have done to prevent the tragedy. And this witness's testimony, however involving violence, is a bit more tame than some of the others that I anticipate we'll be hearing in this trial. So that's why I'm okay with going through some more of these details. So on November 30th, 2021, as it turns out, Miss Darnell was working in her office without a class at the time that the shooting started. She testified that her door was open and she noticed this sort of weird frenetic energy as students were rushing down the hallway. And then she heard three things. First, she heard an announcement from the school principal that the school was in lockdown and that it wasn't a drill. Second, she heard a pop, pop, pop. And third, she heard doors slamming all down the hallway. She said she closed and locked her door and almost secured a night lock on it. And at that point, she said that she saw someone with dark clothing and a mask on make eye contact with her through the window into her classroom. She testified that at that moment, he raised his gun at her and she suddenly felt a force and heard a few pops. She testified that it took her some time to realize that she had been shot in her left arm. Even after this realization, she said that it took her a while before informing anyone about her injury because she thought it wasn't life-threatening and she didn't want to divert any emergency services away from other people who had been shot. And to add more gravity to her experience, when she eventually came back to the scene and saw the bullet holes in the glass, she realized that one was at the height of her head and two were at the height of her heart. Now, after this witness finished her direct examination, the defense chose wisely to not cross-examine her. And one thing to note is that one of the things that the defense attorney said in her opening statement was a statement of wholehearted agreement that this was a horrific tragedy that happened. And so I think that for her case, she doesn't really need to cross-examine someone like this. And on top of that, a witness like this would also be incredibly difficult to cross-examine because she obviously has lived through some very serious traumatic events. She is overwhelmingly a sympathetic witness. And so when the defense attorney chose not to cross-examine this particular witness, I figured that this is probably going to be the start of a trend, particularly with these witnesses who lived through the school shooting, who were there that day, and also especially the ones who didn't have any sort of contact with the parents ahead of time. Anyway, the second state witness was Edward Wagrowski. He is a forensic analyst with the U.S. Secret Service, but at the time of the incident, he worked for the Computer Crimes Unit at the Oakland County Sheriff's Office. He said that he responded to the shooting, helping to reunite parents and students at the reunification point, taking down their names in the process. But the real meat of his testimony was the digital forensics that he analyzed, both about Ethan and his parents. This came in the form of video surveillance footage and data extracted from all of their devices. And this witness's testimony was really important to the state's case because it highlights moments when the parents should have been alarmed about something happening with their kid, as well as some of the things that they did and didn't do leading up to the incident. First, the witness testified that he personally combed through and pieced together all of the school's video surveillance footage to create a timeline of Ethan's progression through the school during the mass shooting. He said it took many, many hours to go through all of that footage and ultimately to piece it together for what turned out to be a 9-minute incident. Then the witness said that he went through the communications that were sent by or to Ethan and his parents. This included a March 8th, 2021 Facebook message thread between Jennifer and James, where Jennifer was freaking out because Ethan wasn't home yet and she was worried he was going to, quote, do something stupid. Then on March 19th, 2021, they discussed how Ethan looked hungover that morning after some sort of crazy incident when he lost all control of himself, and Jennifer decided to make him pass out with a dose of melatonin. Wagrowski also mentioned on the stand that Ethan had exchanged about 20,000 texts with his one friend. All other people he communicated with had a grand total of about 1,000 shared texts. Then on April 4th, 2021, Ethan told his friend that he told his dad that he was having some trouble and that his dad told him to, quote, suck it up. On April 5th, 2021, Ethan told his friend that he was having serious insomnia and that he was considering calling 911 but didn't want to anger his parents. He also shared a number of videos with his friend of himself showing off a gun. Wagrowski also introduced texts between James and the father of Ethan's friend, talking about how the friend suddenly disappeared around October 2021. James learned that the friend had been getting treatment in Wisconsin for some kind of OCD issues, and that's why he wasn't responding to any of Ethan's messages. And Wagrowski showed that after that point, Ethan really didn't communicate with basically anyone. He said that Ethan's phone also didn't show any pings that suggested that he was meeting up with any other school friends at the time. Then, on November 26, 2021, the forensics showed that James took Ethan with him to buy a Sig Sauer handgun. The state's introduced exhibits showing Instagram posts both by Jennifer and Ethan talking about how the parents had bought Ethan an early Christmas present. Wagrowski then talked about the communications between the parents, talking about the horse farm that they were tending to at the time. As it turns out, approximately 25% of their digital communications during this period of time were talking about their horses and their various veterinarian issues. So this did seem to be a particularly large subject that they talked about, at least when they were talking through their devices. And after this, the state played a voicemail that Jennifer received on November 29th, 2021, just one day before the shooting. This voicemail was from school, talking about how Ethan had been pulled out of class for a conversation with guidance counseling about his classroom conduct. Specifically, while sitting in class, his teacher noticed that he was looking at his phone, which was showing images of bullets. The school official said that they talked with him, and he apparently told them about the fact that his parents had taken him to a gun range. And then the school official said that it's basically not really a huge concern. They talked it out and that everything was fine, but that they were just informing Jennifer about it. Wagrowski then showed texts between Jennifer and James later in the day talking about what had happened with Ethan at school that day. It didn't get into details, but it certainly seemed to reference the incident that happened with the guidance counselor. Now, after this point, the state went over what the digital forensics showed from November 30th, the day of the shooting. At 9:24 a.m., Jennifer had missed a call from school. 2 minutes later, Jennifer called back. Shortly after that, the school sent Jennifer a photo of Ethan's math assignment, which had some gruesome drawings on it depicting a shooting and saying words that appeared to be a cry for help. This had been detected by Ethan's math teacher and promptly reported. Then Jennifer texted James, "Call now, emergency." She sent him a copy of the photo and he responds something like WTF, but also that he's with one of their horses waiting for the vet. About an hour later, the parents both show up at Oxford for a meeting with the guidance counselor and Ethan to discuss the drawings. Wagrowski also testified that between seeing the drawing on his phone after being texted by Jennifer and then arriving at the school, James did not stop at home. This is to suggest that he did not take an opportunity to check if their firearms were all there. Then at 10:52 a.m., Ethan leaves the meeting. Shortly after, James and Jennifer also leave and both go on to work. According to Wagrowski, this was the first time that James signed in to DoorDash to start working for the day. Wagrowski also testified that James did not go home after this meeting, despite passing home around 4 times while delivering packages. Not too long after that, James then got an email about an active shooter. He apparently happened to already be at the parent meetup point, but after a few minutes, he decided to go home for the first time since dropping Ethan off for school. According to the digital forensics, he tried calling Ethan and then Jennifer, but neither of them picked up. And while home, James managed to get in touch with Jennifer. He then called 911 to report a suspected identity of the shooter, which was before it was public knowledge who it was. Then before the state passed the witness, Wagrowski showed one more communication from Jennifer to a Brian Maloche. This was a deleted Facebook message that talked about them being, quote, on the run again, and suggesting something about trying to evade helicopters. And as the state passed the witness for cross-examination, the court broke for the day. However, after excusing the jury, there was a short hearing where James ultimately agreed to a limitation in his communications. Basically, as of the end of day 1, he can only communicate with his attorney for the duration of trial, although he can apparently do legal research. I will say that the judge and the attorneys were very careful about the language that they used during the hearing, and it wasn't really clear why James's communications were getting limited. But it was clear that something had happened. As it turned out, it was later reported that the prosecution alleged that James had made a threat to someone over a phone call from jail. From the reporting, it's not clear who he allegedly threatened or what he allegedly said. But if the allegations are true, this is just evidence of someone who's already in a bad position and only making things worse for himself. Like I said, the jury was not in the room when it was being discussed, and they're not supposed to be reading anything about this case outside of the courtroom. So they should have no idea about this allegation, and if James doesn't testify, I doubt that they're likely to find out before they render a verdict. Okay, so that's day 1. On to day 2. On day 2, Edward Wagrowski's testimony continued, this time on cross-examination. Here, the defense attorney actually ran a pretty good cross-examination with short leading questions that basically told the defense version of the facts through the witness. I've referred to this in the past as basically using the other side's witness as something of a hand puppet to say things that are better for your case. And although I wouldn't say that she had completely discredited the witness or anything like that, she did manage to land some points on the board for the defense. For example, for the communications that did not actually involve James, she pointed out, and he agreed, that the witness didn't know if James even knew about that conversation. And when it came to the video of the gun that Ethan had sent to his friend, Wagrowski had testified that James's phone placed him somewhere at home at the same time. But the defense attorney pressed on cross-examination that Wagrowski didn't know whether James was aware of Ethan taking and sending this video to his friend. There was no sound in the video other than the clicking of the gun, and there were no voices in the background. And then when it came to the communications involving James or about James, the defense attorney pressed on the possibility that context could be missing from those communications. For example, Ethan's text to his friend that his dad told him to, quote, suck it up. Wagrowski agreed that he couldn't be sure what exactly James was talking about. And then Ethan's reference to James then giving him a pill, Wagrowski agreed that he didn't know what kind of pill that James had given to Ethan. It could have been Tylenol, it could have been melatonin, both of which are over-the-counter medicines. Then there were the Instagram posts about the parents gifting Ethan the gun. Remember that there was one post by Jennifer and one by Ethan. But Wagrowski acknowledged that he didn't know if James even saw either of those posts. But then the defense attorney made what I think is a bit of an error in her cross-examination. She touched on the point that Wagrowski had said that the first time James went back home to check on his guns was after he learned about the active shooter at the school. This point in her cross-examination, in my opinion, was the one question too many. If you're not familiar with any witness, especially in cross-examinations, there's always a temptation for the attorney to go for the jugular. You want to ask a question that really helps your case with an ideal answer that just makes your argument for you. The problem is when tempted with a question like this, the attorney might forget about the potential side effects of asking it. One could be the answer that the witness decides to give, which is an awful answer for your case and might even make you, the attorney, look really bad. Another potential side effect is what opposing counsel decides to do with your question and the witness's answer when they have the next opportunity to respond. Here, the question that the defense attorney asked was, you don't know if James had any reason to go home earlier in the day, do you? And the witness basically had to answer, well, no, I don't. And that's because anything else would have been speculation into James's mind, and a witness generally can't do that. So the answer from the witness was okay for the defense. But then on redirect, the state picked up where the defense left off and jumped all over it with a bunch of questions that suggested really big reasons why James might have needed to go home sooner. First, there was the photo of Ethan's math assignment that Jennifer had sent him. Then there was the meeting with the school's guidance counselor about the drawings. Then there was the opportunity to go home given how many times he passed by home before word got out about the shooting. So although the defense was able to score some points on cross-examination, this witness really was a big win for the state. Okay, so the third witness was Robert Koteleis. He is a crime scene investigator for the Oakland County Sheriff's Office. I'm not going to go into too many details about his testimony because he largely presented photos of the crime scene. He oversaw the gathering of evidence, so he described it to the jury as they looked at the images. The media, however, was instructed not to show these images, which I'm actually really grateful for because I'm sure they're absolutely gruesome and awful. And at the end of his direct examination, once again, the defense attorney chose not to cross-examine, so he was released pretty quickly. So then there was the fourth witness. This was Cammy back. She's an employee at the gun store where James and Ethan went on November 26, 2021 to purchase the Sig Sauer. She testified that when James had come in, he told her that he had been looking at this gun for a while and was interested in buying it. She said that she had personally sold James a gun previously, so she basically said, you know the drill, give us your ID for a background check. James also certified in paperwork that, according to Michigan and federal law, he was purchasing the gun for himself and no one else. Now, on direct examination, she was also asked about a gun safety pamphlet, which said it was the purchaser's responsibility to secure a firearm. Ms. Back testified that the gun case for the Sig Sauer didn't have a lock. So she sold James a cable lock along with the firearm so that he could secure it. Now, this is very important because, as I mentioned earlier in this video in opening statements, the state pointed out that the Crumbleys' Sig Sauer had a cable lock that had never been opened from its original packaging, meaning it had never been used. But admittedly, a cable lock is not the only way to secure a firearm. So Miss Back's testimony that the 6 Hours case doesn't have a way of locking the gun is important to show that so far, we've only heard of one available way to secure it, and it wasn't used. The defense did cross-examine this witness, and it was mostly about the fact that Miss Back didn't really see James and Ethan communicating in the gun store. For example, Ethan never said anything about this being ultimately his gun, and James didn't say anything about the fact that he was buying it for his son. There really was no indication other than Ethan just being there at the time of the purchase that Ethan even had anything to do with this firearms feature. After that, the defense also highlighted some circumstances that legally allow a minor to take possession of a firearm. One of those is target practice. But other than that, that was it for the cross-examination, and that was it for this witness. The fifth witness was Detective Joe Bryan. He is in the Special Investigations Unit at the Oakland County Sheriff's Department. He said that he interviewed Ethan and eventually also interviewed the parents. And so the jury got to see the full interview of the parents while Detective Bryan was on the stand. During this interview, the parents told investigators that they had just had a meeting with the school counselor and with Ethan that morning about a drawing Ethan had made. Jen said Ethan hasn't been having issues. James then told the police about Ethan's friend moving, about their family dog dying a couple months before, and about his mother dying the previous April. They both expressed that Ethan was basically perfect and that he never got into trouble at school. And then they get into the storage of the 6 Hour at home. James told the police that he had the gun hidden in the case in his armoire. He also said that he had the ammunition in a completely different spot under some jeans. Given what we just heard from Miss Back about the gun case not having a locking mechanism, I think this is pretty bad for the defense. It's just sitting there in the case in his armoire, which is also likely unlocked. I don't know of anyone who locks away their clothes in an armoire. And the ammunition isn't secured at all. It's just sitting under a pair of jeans. The jury is likely to look at these statements and say that James was completely irresponsible for how he stored the 6 Hour. And to my mind, this is about half of what the state needs to show involuntary manslaughter. Anyway, in the interview, James then talked about how he raced home to look for the gun after he heard about the school shooting. He said that when he went home, he found that the gun was missing, and so he called 911. Then both James and Jennifer agreed that they really wished that they had taken Ethan home that day. Now, cross-examination to me was competently done, but didn't move the needle all that much. The defense attorney focused a lot on how James didn't have any concerns about Ethan in the morning when he dropped Ethan off. And this was despite apparently having an argument or at least a hard conversation with Ethan about his poor grades and how Ethan's parents just wanted Ethan to try. The defense attorney also pointed out how much James cared about Ethan. During and after the interview, James indicated that he had concerns about Ethan's safety and well-being, and the witness agreed with that statement. The defense attorney also pointed out how James was sobbing during or going into the interview. And she also pointed out that James didn't seem to be aware of Ethan's social media activity. For example, James said in the interview that Ethan wasn't active on social media, but Jennifer said that Ethan was active on Instagram. So this again brings up the question as to whether James was in fact aware of some of these important details that Ethan was putting out there. The defense attorney also pointed out that in the interview they discussed that James had 3 magazines for the 6 Hour. He said that they were all empty and that they were stored empty and that the ammunition was always kept separately. That said, the way in which James himself described his storage of the 6 Hour, I don't know if the jury is going to zero in on that or maybe let that go, but to me, it really stuck out. All I can say is that if I were on this jury, that would be a very large data point in my analysis on conviction or acquittal. And this was further hammered home by the state on redirect when they went into all of the things that James didn't tell investigators in this interview. And before getting into those details, I will say that the state does employ this tactic quite a bit and quite effectively on redirect of a number of their witnesses throughout this trial up through day 3. For example, what came out on redirect here was that James didn't tell them that he bought the murder weapon 4 days prior. He also didn't tell them that the gun wasn't actually locked up. He also didn't tell them that the counselor told the parents to take Ethan home that morning and that they refused. So in the end, like I said, this proved to be a very strong witness for the state, and most of all for the words that James himself volunteered during that police interview. Okay, so the final witness for day 2 was Kristy Gibson-Marshall. She is and was, on the day of the incident, the Oxford High School assistant principal. I'm not going to go into all of the details of what she testified to, but this was another witness that the defense did not cross-examine. And again, wisely so. She testified very well, and like the teacher Molly Darnell before her, and also like the teacher before her, gave her account of what happened on November 30th, 2021. One thing I will say that stuck out to me is her testimony about how when lockdown was announced, although she was trained to go into lockdown, she did the opposite. She said she needed to make sure that her students were safe, so she went out to see if anyone needed help. And she even came face to face with Ethan at one point and asked him if he was okay. He ignored her and walked on. But that's it for day 2. Now let's talk about day 3. On day 3, the jury heard from 3 more witnesses. The first was the state's 7th witness, and that was Shawn Hopkins. Hopkins was Ethan's school guidance counselor at Oxford High School, so a very important witness for either side here. Hopkins testified that earlier in the fall, the school staff started to detect some issues with Ethan. There were a number of incidents, but basically he seemed down, and some of his homework responses expressed an opinion that his family was a mistake. The guidance counselor sought him out at one point to talk with him, but at this point he felt that it wasn't yet at a level where he needed to involve the parents. However, that did change on November 29th, 2021. This was the day before the shooting, when a teacher noticed him looking at photos of bullets on his phone in the middle of class. While Hopkins was testifying, the state showed the email that Ethan's English teacher sent to Hopkins over the matter. Now, I mentioned this incident in the day 2 part earlier in this video, where the jury heard the voicemail left for Jennifer by the school over this issue. And here, Hopkins testified that he was part of that meeting with Ethan that was referenced in the voicemail. He said that although Ethan had referenced going to a gun range with his parents, he didn't say anything about his parents buying him a gun just days before. And then there was November 30th, 2021, specifically the math assignment with a drawing on it that had some gruesome images. When Hopkins was alerted to it, he pulled Ethan into his office to talk about it. And actually, there apparently are 2 different versions of these drawings on the math assignment. There's the original, which the math teacher took a photo of and sent to the guidance counselor. And then there's the version that was on the physical copy that he ended up obtaining, where most of the details had been scribbled over by Ethan, presumably afterwards. Initially, Hopkins said that he only saw the scribbled version since he took the physical copy of the math assignment when he pulled Ethan to talk to him. And his first impressions were a concern that Ethan was going to harm himself based on what he could see on that page. But he said that he didn't want to just make his own impressions of the meaning of the drawings, so he asked Ethan. When he did, Ethan originally told Hopkins that he was drawing a video game he had seen or that he wanted to develop, and that he likes to draw video games, and basically that he wanted to be a video game developer. So then Hopkins turned to the words that Ethan had written on the page, things like "thoughts won't stop" and "harmless act." And Hopkins pressed him on these statements since it didn't sound like those came from a video game. So then Ethan kept talking, and he started to bring up things that were going on at home. He said school had been really tough recently coming out of COVID. His dog had died, a family member had died, and a best friend had moved away. Hopkins said that Ethan's demeanor while he was explaining all of this was appropriately sad because this was a lot for anyone to be going through all at once. So, because it was still a huge concern, he decided to call Ethan's parents and ask them to come in. When he did, Hopkins also texted Jennifer a photo of the math assignment. Now, when the parents did come in, Hopkins said that it was his hope that the parents would take him home. After all, he testified that this is what parents typically would do when they've been brought in for such a serious mental health issue. Basically, he said that he hoped that they would either take him home to ideally get him immediate mental health help, or even just to give him a good day, since it seemed like he had had so few of those lately. To start the meeting, Hopkins asked Jennifer if she had received the prior day's voicemail. She said yes, and they talked a little bit more about what had happened. This is important because on day 1, during the cross-examination of the digital forensics analyst, the defense attorney made a point to affirm from the digital forensic analyst that he didn't know whether James knew the details of that voicemail since it had been sent to Jennifer, not James. So here we can see that on the morning of November 30th, both parents were present for this meeting while this was being talked about, so both of them were aware of the fact that he had been looking at bullets in the class the day before and why the school was so concerned about this whole thing. Hopkins also brought up how Ethan had mentioned all of these sad things that had happened over the past 6 months. And he said that as he was relaying all of this to the parents, they were confirming that all of these things were true. But he also said that they didn't volunteer any sort of new information beyond what Hopkins already knew. So, for example, they didn't give any details about the friend leaving. They also didn't tell him that they had just gifted Ethan a gun. But Hopkins then handed them a 3-page list of mental health resources and said that he really would like them to get help for their son as soon as possible, that day if possible. And Jennifer said that they would do it, but that they couldn't do it that day. And that's because she said that they both had to return to work. Hopkins testified that he was concerned that no action was being taken. And so he told the parents that he was going to be following up within 48 hours. And so he testified that his plan, had the shooting not occurred that day, was to meet up with Ethan the next morning to see if any action had been taken towards getting Ethan the help that he needed. And if no movement had been made to that end, Hopkins said that he was going to call Child Protective Services. Obviously, that is tragically not how things worked out here. But bringing it back to the end of the meeting, Hopkins testified about why he ultimately decided to let Ethan go back to class. First, he said that as a guidance counselor, he's not authorized to force a student to go home. And second, he said that his prime worry was that Ethan would actually be a danger to himself, and so he wanted him to be around people. So he said that if his parents were going to go back to work, that meant that Ethan would likely be left at home alone. So he figured that if he's at school, at least he's around people. This logic makes sense, but obviously had a huge oversight in that he did, admittedly in hindsight, end up being a huge danger to others. Now, on cross-examination, the defense attorney started by focusing in on the earlier signs of trouble that Hopkins had testified to. Specifically, she pointed out how parents weren't informed about these issues. And so Hopkins, for his part, explained that in these instances, the threat level was lowered by the teacher that he talked to for context, or was lowered by an examination of the other contextual issues surrounding the incident at issue. And he said that if the incident had reached a sufficient level of concern, he absolutely would have involved the parents. The point here by the defense is to show that this track record by Ethan of troubling behavior wasn't so concerned by even other people around the parents up until maybe a day or two before at most. The defense attorney was definitely aiming to play down these concerning signs overall, even from the days leading up to the mass shooting. And one thing that I did notice about this witness is that he actually held up very, very well in cross-examination. Overall, he came across as friendly and caring. But he also wasn't afraid to point out when the defense attorney was trying to basically use linguistic jujitsu to create an unfair impression. And he did it in a way that maintained his friendly and caring qualities, which can be difficult for some witnesses. For example, she asked him if looking at bullets on someone's phone on its own is something that is concerning to Hopkins. And in his response, rather than just saying, yeah, not on its own, he started his response by saying, I think you're kind of trying to put this issue in a pigeonhole. We were trying to gain context of what was going on, and then he finished his answer. And he called her out in this way a number of times throughout the cross-examination in a way that I think plays likely sympathetically to the jury. So although I can commend the defense attorney for her attempt to reframe these facts as it's basically required as part of her job, ultimately, I don't think that she was successful. I don't necessarily blame her for that. I really think it's just the facts of the case. And at the end of this testimony, the impression that I had at least was that there were warning signs that were apparent. And even a school guidance counselor who didn't have all of the information that the parents had could still see those warning signs and tried to do something about them. And ultimately, this gets to the recklessness element of involuntary manslaughter. Hopkins here represents a reasonable person who sees the signs of trouble and is flagging them directly to the parents. So if this jury sees this testimony the same way that I did, which admittedly is not a given, people can take a different impression. This is a very strong point for the state in this trial. Okay, so the state's eighth witness was Nicholas Ejak. He was the dean of students at Oxford High School. Unlike the school guidance counselor, he's more of the enforcer of disciplinary actions. Ejak testified that he first became aware of Ethan's issues on November 29th, the day before the shooting. He received an email about Ethan's in-class viewing of the bullets photos and saw an email after Hopkins had already had the meeting with Ethan. Then on the morning of November 30th, the day of the shooting, he received another email about Ethan, this time about the math assignment with a photo of the drawings. These are the same emails that alerted Hopkins to Ethan's issues. Now, at the same time, the math teacher apparently was so concerned about this drawing that she also went in the middle of class to seek out a person to report the issue personally and found Ejak. While she did, she showed him a photo of the math assignment on her phone. Ejak said that he would alert Hopkins since he was his guidance counselor, and the math teacher then returned to class. So Ejak testified that he went to tell Hopkins about what he had seen, and Hopkins immediately got up to get Ethan. And Ejak said that he stayed for the meeting with Ethan. Because he said that he saw this as more of a mental health issue than a disciplinary issue, Hopkins led the meeting and Ejak more sat back and observed. Ejak also testified that he was later there for the meeting with the parents as well, and he basically corroborated everything that Hopkins said about both of these meetings. Now, importantly, Ejak was asked on direct examination about the circumstances in which he was allowed to search a student's belongings. And this is very important because here we get into the role of the school in this incident, and specifically why no one checked Ethan's backpack or locker coming out of this meeting. This is a point that particularly troubles me personally, and so it wouldn't surprise me if other people on the jury perhaps, are also concerned about the same. And so Ejak said that in order to be allowed to search Ethan's things, he needs to have a reasonable suspicion that Ethan might have something that he's not allowed to have. This might sound very similar to the reasonable suspicion that a police officer needs to have for a reasonable search and seizure. And that's because there is plenty of Supreme Court case law that basically says that the standard is the same. To that end, Ejak noted some things that could tip him off, like if the student is seen with a prohibited item, or if the student is reported to have shown these items or this item to other students. But here, Ejak said that there wasn't anything that tipped him off that Ethan may have brought something like a gun to school. Now, noting that this is a good point for the defense, the state highlighted the fact that he did not have certain pieces of information that potentially could have changed his mind as to whether or not there was enough for a reasonable suspicion. For example, the state made it a point to ask if he was given any details about Ethan's access to firearms, and Ejak said that he wasn't. However, one point that I noticed is that it didn't seem to be the case that anyone asked the parents or asked Ethan about those questions to get those kinds of answers. And honestly, this is one of the big failures by the school, is that they didn't ask these important questions to get this very, very important information. I think plenty of blame can be laid at the feet of the parents for not volunteering this information. But the school also rightfully draws criticism at the same time for the fact that the school staff did not ask the important questions that could have drawn this information out. Now, also on cross-examination, the defense did pull from Ejak that truthfully, he was more concerned about the words that Ethan had written on the assignment than with the violent drawings. And that's because he said that it's actually fairly common for high school students to draw violent scenes from time to time. And so that on its own didn't necessarily indicate a risk. Another thing that the defense attorney referred to on cross-examination was how during one point of the meeting, James turned to Ethan and expressed concern. He said something along the lines of, you know that there are people that you can turn to talk about stuff. You can talk to Mr. Hopkins, your guidance counselor, you can use your journal, and you and I talk. And on the cross-examination of both Hopkins and Ejak, the defense attorney made it a point to say that James never indicated any kind of detail about the journal when he mentioned it. For example, he never mentioned what color it was, or its size, or its texture, or really any kind of details about it other than the fact that it existed. And this appears to be the defense laying a foundation over the course of several witnesses to argue that James wasn't familiar with the contents of the journal, only that Ethan had one and that he kept one. And my gut says that the reason for laying that foundation is probably that whatever those journal entries say that will be introduced later at trial are likely to be very seriously damaging to the defense. And because of that, the defense is going to be arguing that James had no way of knowing that Ethan wrote those things. It is a point that she's validly making, but I don't know if it's going to move the needle all that much. We'll just have to see when we get to the point where the state does in fact introduce those journal entries and then beyond throughout this trial. Okay, on to witness number 9. That was Special Agent Brett Brandon. He was the case investigator with the Bureau of Alcohol, Tobacco, and Firearms, or ATF for short. He testified that when news of the shooting got out, he immediately left to get there as soon as possible. By that point, he said that the investigation had just begun, so he got to work helping with that task. Specifically, he said that he started taking photos of the firearm and its markings so that they could begin the process of identifying the route of the bullets that were fired during the shooting. Then he began putting together the facts for the purpose of putting together a warrant to search the Crumbley family home. After that, on direct examination, the state brought out the murder weapon so that Special Agent Brandon could show the jury how he examined it for markings that he mentioned previously. And after that, the state also brought out the other firearms that the Crumbleys owned, which investigators obtained through the search warrant of their home. And Special Agent Brandon also testified that he personally was part of that search. Now, the purpose of bringing out all of the family firearms was not only to highlight how Ethan begged his parents for the Sig Sauer, which is a more high-powered gun than the gun that the Crumbleys had previously bought him in June 2021. But the state also asked along the way where these firearms were found, where their cases were found, and what state of security these various guns were all in. And surprisingly or unsurprisingly, each of these, with the exception of one firearm which was found in a gun safe, was found in different parts of the home, totally unsecured, with cable locks in their original packaging. And the witness also testified that these handguns were all required to be registered in the state of Michigan, and none of the Crumbleys' handguns were. Next, he was asked about the surveillance footage from the shooting. He said that he reviewed it, and one thing that he said that stuck out to him was Ethan's stance and other aspects of his handling of the firearm that indicated to the witness that Ethan was experienced with guns. And so he decided to see if they could find any evidence of Ethan and or his parents using a firing range nearby. And that's where the state introduced a bunch of videos of Ethan and his parents going to a gun range. They also went through the various Instagram posts and other photos and videos that the jury had previously seen in this case. These videos and photos led all the way up to the day that Jennifer took Ethan to the gun range to shoot his Sig Sauer for the first time. And here it appears that Ethan is actually instructing Jennifer on how to load the gun. So even though this was his first time shooting the 9mm Sig Sauer, it looks like he had done a bit of research on this gun prior to this outing. And just before passing the witness for cross-examination, the state brought up once again the math assignment with the drawings, which the witness had seen during his investigation. And when asked for his impression of the drawings, he said that it looked like Ethan had drawn his actual gun. They put a side-by-side comparison of the drawing of the gun to the photos of the gun that had been taken, and he said that most concerning to him was the fact that next to that was an image of an injured person. Now, this direct was another one that was pretty damaging to the defense, most of all for the fact that the firearms were found for the most part unsecured. And while the first witness, Mr. Hopkins, was strong evidence of James Crumbley's knowledge that he either had or should have had about the risks involved, Special Agent Brandon's testimony was strong evidence of James failing to do what he should have done to prevent the harm that foreseeably resulted. So between those two witnesses in particular, as well as the statements that James made during his police interview, we really do have strong evidence by the state of James's criminal negligence here. Of course, that's my personal impression. You might have a different impression if you've watched the testimony. Either way, let me know your thoughts in the comments down below. But anyway, on Special Agent Brandon's cross-examination, the defense tried to reframe these facts so that the jury might think that the Crumbleys did in fact secure their guns. She went through the ways of securing them, keeping them in a gun safe, using a cable lock, using a trigger lock, locking the case, etc. And then she tried to get the witness to agree that keeping a weapon totally unloaded was also a way of keeping it secure. In other words, she tried to get him to say that there's nothing dangerous about a firearm sitting there in the open without any rounds in it. But this, I think, backfired when he responded that depending on the circumstances, the firearm could still be totally unsafe. And this is particularly the case if the people around it were very familiar with firearms, knew where there was ammunition, and knew how to load the gun. And that basically describes the situation in the Crumbley home. Now, the defense attorney also brought up on cross-examination the videos that they had shown on direct examination of Ethan playing with the gun at home. And like she did with the digital forensics analyst, she pointed out with Special Agent Brandon that he didn't know whether James was aware that Ethan was playing with the gun in that way. This, of course, is to impress upon the jury that James was simply unaware of so many of these issues that popped up before the shooting. Whether any of these points is actually landing with the jury is another question. But at this point in the trial, I do think that both sides are putting on a competent case. However, I think that so far, the facts just appear to be stronger for the state as of day 3. Obviously, I'm going to keep an open mind as trial progresses because maybe all of that changes from here until the end of trial. But for now, that's what I've got for days 1 through 3. Stay tuned for the day 4 recap. I know this one was a bit long, but I think it was really important to get a recap out on all of this testimony that was both comprehensive and as succinct as possible. I do hope you found it helpful, and if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more trial recaps like this one, be sure to hit the subscribe button and the notification bell so you can find out when the next video is uploaded. See you in the next one.